A 700-year-old mosque in central India is now legally a Hindu temple. The Madhya Pradesh High Court ruled in May that the Kamal Mala Mosque, a structure that has stood since the medieval era, is actually the temple of Vagdevi, a Hindu goddess of speech. Muslims who prayed there for centuries no longer have that right. And the case that made this possible didn't start in Madhya Pradesh. It started in Ayodhya in 2019 with a verdict that wasn't supposed to set a precedent but has become a blueprint. The Ayodhya case was supposed to close the book on India's most explosive religious dispute. In November 2019, the Supreme Court handed a contested site to Hindu groups, allowing them to build a Ram temple where the Babri Masjid once stood before a mob tore it down in 1992. The court relied heavily on one piece of evidence, a report from the Archaeological Survey of India, or ASI, claiming temple remains existed beneath the mosque. The ruling was framed as a one-time resolution to a unique historical wound. But it established something else, a legal procedure. If you want to challenge a mosque, you get the court to order an ASI survey. If the survey finds temple traces, you have a case. That procedure is now being deployed across India. In January 2024, an ASI survey of the Gyanvapi Mosque in Varanasi, one of the holiest cities in Hinduism, concluded that the 17th-century mosque was built over a pre-existing Hindu temple. The report cited inscriptions, debris, and structural remnants. Hindu petitioners used the findings to argue the site should be handed over for temple worship. In Mathura, another ASI survey was ordered for the Shahi Idgah Mosque, which stands near a spot revered as the birthplace of Krishna. In the city of Sambhal, a court permitted a survey of the Shahi Jama Masjid after local Hindu groups claimed it was built on temple ruins. The process is mechanical now: petition, survey, finding, claim. By December 2024, at least 11 mosques were facing 18 separate lawsuits, all following the same template. Hindu nationalist groups have compiled lists of hundreds more. A 2022 investigation found that thousands of mosques across India had been identified by these organizations as potential targets, each one alleged to have been built after destroying a Hindu temple. The scale is not speculative. It is organized and methodical. India's Places of Worship Act, passed in 1991, was supposed to prevent exactly this. The law froze the religious character of all places of worship as they existed on August 15, 1947, the day India gained independence. No mosque could be turned into a temple. No temple into a mosque. The status quo was legally locked. But the Ayodhya site was explicitly exempted from the law because it was already under litigation. That exemption has become the gap through which everything else is now slipping. Hindu petitioners argue that the 1991 law doesn't prevent courts from determining the original character of a site. If a mosque was built over a temple, even centuries ago, then the true religious character is Hindu, and the law doesn't apply. The Supreme Court, by accepting ASI evidence in Ayodhya, gave weight to that argument. The institutional machinery is doing what courts and archaeology are not designed to do: adjudicate history. The ASI is a government body, not an independent research institution. Its surveys are conducted under court orders, in live legal disputes, with findings that carry immediate consequences for religious communities. In the Gyanvapi case, the survey took place while Hindu and Muslim groups protested outside. In Sambhal, an ASI survey in November 2024 triggered violent clashes that left 5 people dead. The investigation isn't neutral archaeology, it's forensic evidence in a religious property case. What the Ayodhya verdict proved is that demolishing a mosque is illegal, but reclaiming it through the courts is not. The 2019 ruling acknowledged that the Babri Masjid's destruction in 1992 was a criminal act. But it still awarded the land to the group whose ideology motivated that destruction, based on archaeological claims about what existed there 500 years earlier. That combination, condemning the mob while rewarding the claim, sent a signal. You don't need to tear down a mosque. You need a lawsuit, an ASI survey, and a favorable reading of buried stones. The Supreme Court tried to contain the damage. In December 2024, it issued an interim order barring lower courts from registering new cases challenging places of worship. But 5 months later, the Madhya Pradesh High Court declared Kamal Mala a temple anyway. The freeze didn't hold. The precedent is stronger than the pause. And the question now is not whether more mosques will face legal challenges, it's how many, and how fast.